a sensitive place is absolutely, it's absurd.
So
And
California is basically trying to say everything's a sensitive place.
yeah, I mean,
That's
it's,
Gavin Newsom's new way of doing it.
yeah.
Yeah.
Now, thankfully, this law has been challenged, and there's been a preliminary injunction issued against that. And what a preliminary injunction is that's the court saying that we think the plaintiff is going to win. We're not saying that for sure, but there's a strong enough likelihood they're going to win that we're going to stop whatever it is they're suing over, the conduct they're suing over, for the pendency of the case. So that for the time the case is going on, you can't enforce, in this case, enforce Gavin Newsom's law. Now, I have a very similar lawsuit out of Hawaii. I filed that, um, gosh, I want to say about June of last year. And so was mine was filed a little bit before the California case. I also received a preliminary injunction. So in Hawaii and in California, the laws that we're talking about aren't being enforced, at least in part. I mean, there's some things that weren't challenged in both cases, these new laws, but the major issues, in my case, parks, beaches, banks, restaurants serve alcohol. The signage requirement has been struck down as unconstitutional. I'll note that the signage requirement, what I call the default rule, has been struck in every single court of the country. That's really good news because there's been a lot of judges you wouldn't expect be in favor of firearms rights. But the truth is,
That's shocking.
it's such an absurd law that many judges that don't have a track record of a strong Second Amendment jurisprudence are striking that law down too. Nationally, it's more of a mixed bag, but I will say this: in Hawaii and California, anything that was challenged was enjoined. So
Wow.
the reason I'm talking, even though we're talking about a California case and California law, the reason I'm bringing up my Hawaii litigation is the fact that both these cases have been appealed up to the Ninth Circuit. The Ninth Circuit is a court of appeals. So a lot of people might not know what how the federal court system works. In this country, this is a generality. There's exceptions, but typically what happens is you file a lawsuit in a trial court. Trial courts are also called district courts. You get a decision. That decision is binding between the parties only. If one of the parties does not like that decision, they have a right to appeal the decision. Now, there are many appellate courts in the federal circuits. They're called federal circuit courts. And California and Hawaii is in the Ninth Circuit. The Ninth Circuit, when the Ninth Circuit makes a decision and they call it a published decision, that sets the law for all the trial courts underneath it. So that's for 7 states: Alaska, Washington, Oregon, Hawaii, Arizona, California, and I can never remember. It's either Montana or Minnesota, whichever one's closest to the coast. So that sets the law for all of them. So if a case comes out of Alaska, it goes up to the Ninth Circuit. That is the law for California as well, and it's binding. So a court can rule on a case. In Idaho, yeah. So let's say a case comes out of Idaho, goes up to the Ninth Circuit. That sets law for California, and so in April, I will be taking my Hawaii case up to the Ninth Circuit, and I will be arguing that, and that's going to set the precedent for the entire Ninth Circuit. Now, California case, in all likelihood, will be heard on the same day, immediately after me. And, that case addresses some issues that weren't covered in I focused in my lawsuit on the issues that were most pertinent to my clients, whereas the California case is a bit more of a broader lawsuit. And they'll be evaluating a couple of issues that just aren't an issue in my lawsuit. But in my case, Hawaii has a ban on carrying in banks, parks, beaches, and establishments that serve alcohol. And then there's the default rule, along with a number of government parking lots that there's a law that says part of the law is you can't carry in a parking lot of a place where it's prohibited. Well, the issue is you can't carry in a government building, for example, right? Well, the DMV, where my clients go to, and they live in Maui, is in a strip mall. And so there's, about 30, 40 businesses in that share a parking lot with that DMV. So if you want to go to, the restaurant adjacent to the DMV, or if you want to, any of the businesses, you want to go grocery shopping, you can't carry in that parking lot, even if the grocery store wants to let you and has put up a sign saying it's allowed. So, and that's the same in California. So, it's going to be a big day for gun rights and constitutional law in general. We're really got to go for it in April. And the other side's brought in some big guns. They in Hawaii. They've hired the former Solicitor General of the United States to come in and prosecute the case. And I'm sure California will have some very high-level litigators as well. And so my case will set the law for how the California case decide. Now, as a practical matter, to be heard the same day, I mean, they're just going to make a decision on both of them. But we have both good and bad news around the country. There's been a series of cases that have challenged these similar laws. The most notable for our purposes is the Antonyuk case. The Antonyuk case is out of New York. And the Second Circuit, which is the appeals court for the state of New York, Connecticut, and one of the other adjacent states, has already ruled. And unfortunately, it's upheld much of what we're calling the post-Brune bill law. However, it did strike the default rule down as unconstitutional on Second Amendment grounds, and it struck down a ban on carrying churches on First Amendment grounds, free exercise grounds, your ability to exercise religion. And then it strongly suggested that a ban on rural parks would be unconstitutional, even though it wasn't actually striking the ban down for some procedural reasons I won't go into. It just would be pretty tedious for most people to listen to. Certainly it was. And so have some good news from New York and some bad news. The default rule is the rule that impacts by far the most people and impacts people's day to day. So at a bare minimum, we're going to be able to rely upon the New York case for the proposition that the signage requirement is completely unconstitutional. Secondly, why we've got rural parks looking pretty good, I think, because Maui County, where my clients live in, it's a pretty rural county. I mean, we're not talking about New York City. So we've got that's the flagship case. That was the first appellate court to rule on this issue. Elsewhere, we've got the Third Circuit. Third Circuit has, in a trial court decision, has struck most of these post-Brune bills, but and now it's up on appeal. And it's looking very similar to the New York case. Default rule and a couple of the really extreme stuff. I think the Third Circuit's going to be amenable to striking down just based upon a couple orders they've issued, but they're upholding a lot of things too.
So there's going to be a jurisdictional split, possibly, that may have to go up to the Supreme.
Very possibly. Next, we have court in Maryland. The trial court in Maryland struck the default rule and the rule that you can't carry in a establishment that serves alcohol, but it upheld parks and a couple other things. Now, I think to illustrate what we're talking about, it's important when there's a ban on an establishment that serves alcohol.